Hold up, grab my soda cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape paint. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over this bit, non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions. Man up, slaves, and hit those buttons, or I'll send ice.
Hey, greetings everybody. Keith here, hoping everybody's having a good day, enjoying life, living life, loving life. I want to take you first to P.I.G.S.C.U.N.T.S rides again. P.I.G.S.C.U.N.T.S rides. Got a new platform I'm going to be starting up, and basically what we're doing is, thanks for joining me in my journey so far. I appreciate all of you. My attempt at expanding into something other than law has led me to start a debate platform, something that instills the trueness of a great topical exchange, an etiquette that is the functional mechanism of forward progress in any discussion. Please join us at P.I.G.S.C.U.N.T rides for our new stream, which will be held weekly as a debate platform with interactive functions for the chat as well as panelists. Help us build and grow by subbing now. Let me grab this link. The Short Bus Podcast TV, where you get a short ride on a short bus, one way out the door if you cannot stick to the etiquette required. This is so that any discussion can effectively help educate the audience to truthfulness of the facts on any topic. Bring your sources, not your insanity and feelers. So please join me at P.I.G.S.C.U.N.T rides. The link is in the chat. Please go over and subscribe. And let's get into it. I gotta get my screen share up here. Okay. And basically what I'm doing tonight is I'm going over the event timeline and case law that points out various different problematic issues, procedural, legal errors that we're looking at. So the first one is the transition from a wrongful eviction to a constructive eviction. the court process, which was wrongful, and then in that court process, the result of the landlord's conduct and the court's failure to intervene. What we're talking about here is when the plaintiff got on the stand and admitted that she violated the statutes that she is obligated to or has a duty to fulfill in her contract under rental agreements. And when a landlord admits on the record to violating notice requirements and then uses a voluntary dismissal to avoid a judgment of retaliation, they have engaged in a constructive ouster, constructive eviction. Iowa case law, the admitted breach and retaliation. In Iowa, the leading case for retaliatory eviction is Hillview Associates versus Bloomquist, 1989. I believe I've mentioned this one before. And in that case, the ruling was the Iowa Supreme Court established that once a tenant proves a good faith complaint was made, like our December 16th noise complaint and the January 5th accommodation request, the mandatory presumption of retaliation kicks in. It's mandatory. It's a mandatory presumption of retaliation kicks in, and we'll talk about that later. It's mandatory because of the language used in the statute says they must presume retaliation. So again, we'll talk about that later. The constructive element. If a landlord's actions, like filing a basis clear and present danger, as in our situation, make the dwelling effectively unavailable or create a hostile environment that forces the tenant out, it is a violation of Iowa Code 562A.26, tenants' remedies for landlord's unlawful ouster. Admission on the record. Under Iowa law, a judicial admission, an admission made by a party during a hearing, is considered conclusive evidence. In Lewis versus John Jager, Iowa 2012, the court ruled that when a landlord bypasses the legal eviction process, even through voluntary lockouts or administrative maneuvers, such as in ours, they are liable for damages under the IRLTA, which is the Iowa Uniform Residential Landlord Tenant Act. Mentioned that several times. Federal case law under the Fair Housing Act, which I've mentioned before, which holds the requirements for the ADA recognition of request for reasonable accommodation and retaliation, because our hinge involves a disability accommodation request. Our case moves into the realm of Civil Rights Act. Okay. Constructive eviction under FHA, federal courts, including the 8th Circuit, which covers Iowa, recognize that a constructive eviction occurs when a housing provider makes a dwelling unavailable through harassment or by ignoring accommodation requests. This is federal. Okay. Federal case law was determined first, and then Iowa came in and confirmed it. United States versus Rupp, 8th Circuit Court, 2022. This recent case reaffirmed that a landlord's retaliatory intent can be inferred from the timing of their actions. If someone or evicting someone immediately following a protected activity, like a request for an accommodation or a report of a hazard, is a violation of 42 U.S. Code 3617. In Alexander versus Riga, 3rd Circuit, held that otherwise making a dwelling unavailable includes a broad range of conduct, including using the court system in bad faith to force a tenant out. Okay? And you guys can look all these codes up that I'm going to be giving. Go ahead and look them up. 42 U.S. Code 3617. And the confession on record as a federal trigger If the landlord admitted in Magistrate Feldkamp's court that they failed to provide a 7-day notice, but proceeded with the eviction anyway, they have confessed to a due process violation. See, your due process isn't strictly just government officials and stuff, government entities. It belongs to any business that you're associated with conducting consumer affairs as well. If they are not going to provide you the process due, then you have a civil rights claim. Okay, this is why they have this case in front of the courts for the guy making cakes, and he's saying it's a violation against his freedom of speech to force him to make cakes that go against his religious beliefs. And that's the whole crux there. The next one, Miller versus Amos strategy in 2024. This recent case highlights that a landlord's notice to quit is invalid if it is based on a discriminatory or retaliatory motive. And it shows retaliation if they ignore my complaint, but then take upon the upstairs tenant's complaint and take us to court on it. And again, I want to remind everybody, the landlord even failed to give a 7-day notice to cure to us in regards to the eviction from that upstairs tenant and his claim that he felt he was threatened because I was yelling at him. If the landlord admits they didn't follow the statute, the entire notice to quit becomes a legal nullity. If the landlord admits they didn't follow the statute, the entire notice to quit becomes a legal nullity. In other words, it's saying they have no standing. And the court must recognize now that a plaintiff came to court and issued a suit with no standing. Summary of the constructive eviction foundation. We argue that the constructive eviction was finalized not by a sheriff's deputy, but by the court's administrative conduct, which is applied in contradiction to Iowa rules of civil procedure. The confession. Landlord admits they failed the statutory notice, the Iowa Code 562A.27 that I mentioned in the earlier videos. They have a maintenance that they are required to follow, and that is the maintenance of the rental agreement. When a tenant gives a noise complaint, they are required to give a 7-day notice to the offending tenant. They did not do so and then sought an eviction later on within 1 year. The trigger. Landlord admits the eviction followed a January 5th accommodation request, as well as our December 16th noise complaint. I guess I forgot to put that in there. The constructive ouster, constructive eviction. By allowing a voluntary dismissal after these admissions, the court aided and abetted by not following their strict statutory duty. So now we have a landlord, a property manager that failed the strict statutory duty twice, once against the IRLTA, the Landlord-Tenant Act, and once against the Civil Rights Act. The landlord in making our housing unavailable without a lawful basis. This shows one of several things: incompetence of any level, bias, conspiracy, etc. Either way, it is it is 18 U.S.C. 4, misprision of felony violation, which carries a 3-year sentence. In other words, the court has in, on, and for the record an admittance of a felony by the property manager, and they are required to report this. This is nothing compared to tampering with the witness, victim, or informant, which carries up to 20 years. So now if they fail to listen to us, we have them all on tampering with a witness. The confession on record as a trigger for 42 U.S.C. 3617 FHA retaliation and the Eighth Circuit precedents that define making a dwelling unavailable through administrative bad faith. The federal foundation is the FHA and constructive ouster. Under the Fair Housing Act, specifically 42 U.S.C. 3604F and 3617, it is illegal to otherwise make a dwelling unavailable because of a disability or request for accommodation. This is where they're required to take into consider the request for accommodation and try to make amends privately. Try to make other accommodations privately by moving us to a different dwelling or a different unit, or moving the offending tenant to a different dwelling or unit. They did not. Federal case, 8th Circuit, Ellis versus City of Minneapolis, 2017, and related 8th Circuit guidance confirmed that making a dwelling unavailable isn't just changing locks. It includes using procedural harassment, like bad faith evictions, to force a protected person out. The admission trigger, since the landlord admitted on the record at Magistrate Feldkamp's hearing that they did not follow the 7-day notice requirement of Iowa Code 562A.271, their filing of clear and present danger eviction was knowingly false legal action. In federal terms, this is interference under Section 3617. And this is why I say tampering with a witness, victim, or informant, which carries up to 20 years, because they are, in fact, interfering. In federal terms, this is interference. So the landlord interfered with our rights, admitted to it on the record, and the court is now interfering with our ability to go forward. Again, I remind you, all these dismissals are being presented to Judge Abbott, who is biasly dismissing things. The plaintiff's dismissal did not get any resistance from us because he never presented it to us. He just biasly dismissed it on their behalf, favoring the plaintiff, despite the strict statutory duty of the court to report a felony by the plaintiff. Iowa State Foundation, the confession of breach in Iowa, a judicial admission, what they said in court, is conclusive. Hillview Associates versus Bloomquist, Iowa, 1989. This case is the ironclad rule for our situation. It states that once we show a good faith complaint, December 16th noise complaint and the January 5th accommodation request occurred within 12 months of the eviction filing, the presumption of retaliation is mandatory. They use the term must. That means it is mandatory. They must find a presumption of retaliation. They cannot just wantonly, biasly give a dismissal without bringing the presumption of retaliation and giving the landlord opportunity to rebut it. And that's what we're screaming about. The breach, because they admitted they skipped the notice to cure, they essentially confessed that the eviction had no legal basis, that they had no standing in court other than to remove us after our complaint. This is constructive eviction because the legal process was used as a tool for the eviction rather than a pursuit of justice. Why constructive eviction matters legally. By labeling a constructive eviction, we move our dangers. We move our dangers from the small claims limits of $6,500 into the unlimited civil rights damages. And if you remember, I told you I started out in the beginning, we were only thinking we were going to claim 10,000. Then it moved up to 100,000. Now it's up to 250,000. And again, if we have to continue on, we may move it up even higher. The small claims judge, you moved out, so the case is over. That's effectively what they're saying. They're saying since I moved out before the judge handed down the merits of the case, that the case is over. That's not the way it works. Chief judge in federal court, they forced us to move out by abusing the court system after confessing to a breach. This is a constitutional injury. They admitted they violated both the IRLTA and the Civil Rights Act and yet got a dismissal. The court has engaged in a structural obstruction of justice. The court themselves has engaged in a structural obstruction of justice by denying an indigent, disabled litigant the record of a landlord's confessed crimes. The court is not merely making a ruling, it is tampering with the integrity of the appellate record in violation of the principles of 18 U.S.C. 1512 and the Iowa Code of Judicial Conduct. Greetings, sister. I am well. I am well. Appreciate it. Drop my link down there for my new channel. Thanks to being inspired by yourself. I appreciate it. Hope you'll join us. Go over and sub up and get ready to do some debates. I love your candor and how you present yourself. I would love to see you over there. In the meantime, let's get back to it. Phase 1, the trigger, upstairs tenant and the FHA. The foundation of this case isn't just noise. It's a breach of the covenant of quiet enjoyment. This is part of your lease agreements. Everybody has, in a lease agreement, a covenant of quiet enjoyment. This is why they have noise ordinances. The violation here is the tenant upstairs who violated the rental agreement through excessive noise. The landlord's failure under the Fair Housing Act and Iowa Code 5628.15, the landlord has a duty to maintain a habitable environment which encompasses quiet enjoyment. If a landlord is aware of a tenant-on-tenant harassment, especially involving a disabled tenant, and fails to act, they are liable. The federal authority for this, in Nutica versus Bois Claire Corporation, 8th Circuit, 2003, the court ruled that a landlord's failure to stop harassment by other tenants can constitute disability discrimination under the FHA. Phase 2, the statutory breach, the property manager's admission. Property manager is now using the court to remove the victim, us, the complaining tenant, rather than the problem, the noisy tenant. The 7-day failure under Iowa Code 562A.271, a landlord must provide a 7-day notice to cure upon a noise complaint. The retaliation admission. On January 26th, the manager admitted on the record that the eviction filing followed our January 5th accommodation request and the December 16th noise complaint. The mandatory presumption under Iowa Code 562A.36. Once we showed that timeline, the judge had a strict statutory duty to presume retaliation. As established in Hillview Associates versus Bloomquist, 1989, the burden shifted entirely to the landlord to prove they weren't retaliating, a burden they could not meet because they had already admitted to the notice failure. Phase 3, the 3-card Monty, judicial abuse and tampering. This is where they're shuffling the judges. I'm calling it a 3-card Monty in case you saw my other videos earlier. This is where the constructive eviction was finalized by the court. by shuffling the case through 4 judges, Cooley, Lubin, Feldkamp, and the current Judge Abbott. The system seems to be ensuring the confession on record will never be turned into a final judgment. How this mirrors witness or evidence tampering under 18 U.S. Code 1512 and Iowa Code 720.4. Again, I urge everybody look these codes up, find out what they say, and you will find out there is mandatory, strict statutory duties in the language. Corrupt hindering of a proceeding by allowing a voluntary dismissal against the rules of procedure after the trial, which is Iowa Rule 1.943 of civil procedure. The court corruptly persuaded the record to disappear. Like I said, they're trying to silence the evidence by the plaintiff of coming to court with dirty hands, with no standing, and then gave a decision favoring that very plaintiff, knowing that they are the ones that violated both state and federal laws. Without withholding a record, by denying our informa pauperis status, the court is gatekeeping the appeal process and transcripts. If we cannot pay, the higher court cannot see the confession. Under 18 U.S.C. 1512 C.2, otherwise obstructing or impeding an official proceeding includes acts that make evidence unavailable. It is tampering. They are subject to a 20-year sentence here if they're not careful. Retaliation against a witness. We are the witnesses to the landlord's crimes. By making the court process so expensive and administratively possible, the court is harassing a witness in retaliation for exercising the legal right to a meaningful hearing. Okay? You have a right to a meaningful hearing under the Due Process Clause. Again, statutory under a meaningful hearing. And I'll go over that information one of these days too. The voluntary dismissal is not a summary judgment. Voluntary dismissal, especially one without prejudice, is a procedural exit. It suggests that the case simply ceased to exist without the court deciding who was right. The flaw. Under Iowa Rule of Civil Procedure 1.943, once the trial started on January 26th and was under advisement, the plaintiff lost the absolute right to exit. Okay? When the judge took it under advisement and didn't give an order that day as to the finding, they took it under advisement. That removes it from the plaintiff. It's now strictly the judge's determination, and they're supposed to wait for that determination. Conveniently, they snuck in with a dismissal and presented it to Judge Abbott, and now Judge Abbott keeps taking all of the filings that were filing and dismissing them, denying them. Okay, the summary judgment reality. In our case, because the plaintiff admitted the statutory violations on the record, there were no longer any disputed facts. The judge now had a duty, and they're removing that duty from the judge. When there are no disputed facts in the law, IRLTA dictates a specific outcome. The court has a duty to enter a summary judgment, a ruling based on the undisputed evidence, rather than letting the plaintiff walk away. That's their strict statutory duty, is a summary judgment ruling based on the undisputed evidence. See, once they admitted on the record that they violated the law, that is a judicial notice. They must give a summary judgment. It cannot be dismissed. Source of law versus force of law, the mandatory part. Statutory Code 562A36 of Iowa. The mandatory part is the word presumption. In Iowa law, means the judge must rule for us unless the landlord disproves it. The word presumption in Iowa law means the judge must rule for us unless the landlord disproves it. The landlord didn't disprove it, they confessed to it. The force of the statute requires a final judgment of retaliation. Iowa procedural rule, civil rules of civil procedure is restrictive. It limits the court's power to allow a dismissal after trial has begun. The force of this rule says the dismissal was voidable the moment Magistrate Feldkamp took the case under advisement. Under the constitutional due process, which is overriding the right to record and a decision by the person who heard the evidence. Okay, this is the right to a meaningful hearing. Why have a hearing if you're going to go in and threaten eviction and then force us to move out, and then once we move out, voluntarily dismiss? No, you have an obligation to stay on the field. You can't just walk out of court and say, okay, well, he moved. We're no longer concerned about it. No, you were concerned about it and went forth with the actions and then admitted your federal and state violations on the record. Why our filings are the bridge to a final judgment. By filing the motion to vacate dismissal, we are telling the court, you cannot close this case with a summary exit dismissal. You must close it with a final judgment on the merits, because the trial was already completed and the evidence, the confession, is conclusive. In legal terms, a summary judgment is what happens when one side is so obviously right based on the facts that a full trial's deliberation isn't even needed. Judge didn't need to hear any more evidence. They admitted on the record that they didn't evict us for non-payment of rent or anything, but they evicted us without knowing that they had a statutory duty prior to the eviction. 2 statutory duties that they ignored. Since the plaintiff admitted to the notice failures, we are essentially asking the Chief Judge to treat the January 26th hearing as a motion for summary judgment that we already won. The evidence is there. It's clear and present. Unlike the danger, it is clear and present confession. Finality versus closed. The landlord's view, the case is closed, dismissed, I'm safe. No, you're not, bitch. I am not stopping. I am not stopping. Even if I don't get this appeal, I'm investigating you. I'm going to point out every error you are making. And every time I find out you are evicting someone, I'm going to be that court watcher. I'm going to the eviction court. I'm going to watch. And every time you step into that court, I'm going to be there. The legal truth, a case that is dismissed without a final adjudication on the merits is unstable. By filing our motion to vacate and notice of appeal, we are preventing that dismissal from becoming final. We are forcing the court to either confirm the dismissal, which we then appeal as an abuse of discretion, or vacate the dismissal and enter the judgment we are owed. This is the evidence they now know, or they know they are wrong. They would have already declared dismissed with prejudice, meaning barred from ever bringing this specific claim again. By filing into the case when dismissed without prejudice, we are proving there are strict statutory duties that are not fulfilled. The source of law, Iowa Code 562A.36, says if retaliation is presumed and confessed, the court must find for the tenant. The force of law, That must is not a suggestion. It is the judge's job description. It is their job to find it a no standing situation for the landlord and give us the award for the case. The court's acceptance of a voluntary dismissal was a procedural legal error that avoided the force of law required by Iowa Code 5628.36. Because the plaintiff admitted to the material breaches on January 26th, there was no longer a triable issue in fact. The court's only lawful path was to enter a summary judgment on the merits. This filing is the defendant's demand for that final judgment, to which I am entitled as a matter of strict statutory duty. That's that due process clause. They have a strict statutory duty for that. A voluntary dismissal without prejudice is a tool for the beginning of a case, not the end of a trial. Okay? Understand the language, understand the words, understand the terms they're using, and you will understand this stuff. You will come to a comprehension of how this stuff works. A dismissal without prejudice is a tool for the beginning of a case so that you don't have to waste the funds and time to go through a full trial. Okay? Because the plaintiff confessed to the statutory breaches on January 26th, the force of Iowa Code 5628.36 converted this matter into a summary judgment. In other words, it's something they cannot avoid. They confessed to their dirty deeds on record, and now that summary judgment is already there. They provided that summary judgment. They made the admission that they violated the law. The court's attempt to characterize this as a dismissal is an error of law. It must be recorded as a final judgment on the merits with prejudice against the plaintiff. And the prejudice would come against the plaintiff because obviously we'll give them the opportunity to rebut the retaliation presumption. But they can't do that. They've already admitted and confessed that they did not follow the law. By demanding the court enter its own judgment, we are asserting that the court cannot outsource its integrity to a plaintiff who wants to run away after losing. We are holding them to the oath of office, which requires them to decide cases based on the evidence presented, not on which party wants to quit first. We are in this for the long haul. Like I said, I ain't going to stop. Failure to report a known felony, tampering with a record, hiding a record as part of that failure, and tampering with a witness, victim, informant as part of that failure. We're not here to provide the court with a path out of its own error. We have provided the record of the plaintiff's confession and the statutes they violated. The court has a strict statutory duty to enter a final judgment. To do anything less, to allow a dismissal to stand in the face of a confessed breach, is a failure of the judicial office and a violation of public trust. End of story. There's no longer a dispute over a rental agreement. This is a constitutional crisis. We are not the only ones that go through this. And like I said, I will not stop. When the court uses the magistrate's shuffle to suppress a record of confessed federal and state violations, it violates Article 1 of the Iowa Constitution and the 14th Amendment of the U.S. Constitution. The court is not shuffling judges. It is shuffling away our right to due process and a meaningful remedy. They're destroying the very impact of justice on the people that deserve it. The Due Process Clause, which is under the 14th Amendment of the U.S. Constitution and Iowa Article 1, Section 9. The most significant violation here is the denial of procedural due process. The right to a meaningful hearing. Due process requires a hearing at a meaningful time and in a meaningful manner. By allowing a voluntary dismissal after the hearing concluded, the court rendered our hearing meaningless. It allowed the plaintiff to treat the court as a practice run where they could bail out the moment they confessed to a violation. The neutral arbiter violation. When a case is shuffled through 4 judges to avoid a judgment on confession, the judiciary is no longer neutral. It has become an active participant in protecting one party from the legal consequences of their testimony. In Iowa specificity, the Iowa Supreme Court has held often that Article 1, Section 9 of the Iowa Constitution provides broader protections than the federal version. In State versus Hernandez-Gigante, the court emphasized that fundamental fairness is the touchstone. There is nothing fair about a shuffle that buries a confession. The right to a remedy, open courts, Iowa Article 1, Iowa Constitution Article 1, Section 1, has a specific right to remedy clause. The violation by denying our informa pauperis, the status for the transcript, the court is putting a price tag on justice. If you cannot afford the transcript of the confession, you are effectively barred from the appellate courts. If you cannot afford the transcript of the confession, you are effectively barred from the appellate courts. This is a constructive closure of the court system. Under the Iowa Constitution, the courts must be open to every person and a speedy remedy offered for every injury of person, property, or character. And I'm telling you, folks, we're having a rough time. So if you see my PayPal link down in the details, please feel free to help out a little bit. Every little bit helps. Took every penny we had, almost $5,000 to make the move. And here we are at the end of the month, waiting for the next check. And we have to pay $200 for the transcript fee and $200 for the filing fee for the appeal. And we run short. So please feel free to help out. The right to petition for redress is the U.S.'s First Amendment. The right to petition includes the right to access the courts without fear of retaliation. The violation is when the courts allow a landlord to file a clear and present danger eviction, specifically because we requested a disability accommodation. The court is aiding and abetting a violation of our First Amendment rights. The court's role: if the court fails to enter a judgment on the admitted retaliation, the court itself is chilling our right to petition for repairs or accommodation in the future. Equal protection, again, under the 14th Amendment and the Iowa Constitution, Article 1, Section 6. The violation, magistrate shuffle, creates a class of one situation. Other litigants get a final judgment from the magistrate who heard their case. We, however, were subjected to a specialized administrative shuffle that prevented a final judgment. Under Village of Willowbrook versus Olek, 2000, the U.S. Supreme Court ruled that if a government official treats an individual differently from others with no rational basis, there is no rational basis for allowing a plaintiff with dirty hands to enter a dismissal voluntarily and then grant them. It goes against the rules of civil procedure. It goes against the strict statutory duty of their codes, and they allow somebody with dirty hands to enter a court of equity, seeking equity, to receive equity, even though they had dirty hands, and admitted the dirty hands on the court. Especially with ill will, it is a violation of equal protection. The shuffle has no rational basis other than to bypass the confession of the landlord. An unconstitutional act is considered void ab initio from the beginning, meaning it has no legal force, confers no rights, imposes no duties, and is in legal contemplation as inoperative as if it had never been passed. Originating from the Supreme Court case Norton versus Shelby County, 1886, this principle dictates that such acts cannot supersede existing valid laws. This is effectively trying to silence our constitutional claim. Let's see, we got all kinds of notes in here now. Greetings, everybody. Captain Action, justice delayed is justice denied. Absolutely. I already have their indemnification bonds for all judicial officers from the last case that I went into, the failure to appear for jury duty. Yeah, and their oath is not needed. It's already presumed. Landlord to residential living. Yeah, it's one of those funny things people don't understand the language. It's the Iowa Uniform Residential Landlord. See, it's the landlord that is the resident. He's the one that's required to have the operating license. He's the one that's determined by necessity to be a resident, federal, state, or municipal officer or agent. That's why it's the Uniform Residential Landlord and Tenant Act. The tenant is not a resident. The landlord is. Let's see here. Judge's job, especially for an equity proceeding and an equitable action. Absolutely. And eviction in Iowa, I don't know how it is in your state. You would have to look it up, but I'm pretty sure it's going to be the same, that it is an equitable action because you're dealing with livelihood, ejecting a person from their home. Equity is prejudice to unclean hands, unrighteousness, and bad faith. Yeah. Yeah, I might even do a short video on it. Micah L. says, sounds like a TikTok trend video. The magistrate shuffle, justice for sale, denial, and delay. So yeah, I might make a short video, a satire video on it. Got Ismail up in there. Yeah, how you doing, brother? And yes, it has moved from misfeasance to malfeasance now. Absolutely. And maladministration, yes. So anyway, let me pull something up here. I'm going to pull my PayPal link up for anybody who wants to help share some love. Like I said, folks, we're after our $5,000 move, we are strung out. We have almost nothing left, and it's getting very tight. So we're hoping somebody will be able to help us out. Let's see here. Oh, that's right. They made me remove that because it had no bank account attached to it. Well, I'll be damned. I'll have to do it some other time. I'll post my PayPal here somewhere soon. So if you guys want to help, I would appreciate that. But in the meantime, I hope you guys understand it's your responsibility to step up and learn this stuff, because no attorney will help you. The judges won't help you. They will try to hide it for the plaintiff. The plaintiffs that are bringing these cases are the businesses. It is a corporatocracy. It is a capitalist oligarchy. They all play for the money. They are not in there for equity. And you have to hold them to equity. By knowing equity, you have to know how to do your research in the laws, both state and federal. You have to understand the constitutions. And this is why I urge everybody, that public education system is an indoctrination system. And we have all been indoctrinated to a stupidity level. And I urge everybody to put a little effort into it, into your own education and the education of your children, because it's much better outcomes if we could enforce these laws ourselves. We don't need other people to enforce them for us. We need to be the oversight of this federal government. We need to be the responsible parties. And you can't be responsible if you've only got an 8th grade reading comprehension. That's the average reading comprehension for Americans, is 8th grade level. And that's disgusting. Everybody is provided a education by the public education system, but the problem is that it stretches it out over 12 years for nothing but to indoctrinate you into a certain process. And that process is devoid of any kind of legitimate reason or substance. Reading, writing, and arithmetic is very easily learned. We learn that the basics at a very young age. So what is the rest of the school years for? It's to indoctrinate you into a process, nothing more. So think about this stuff and pay attention to future videos, as I hope to bring more about this stuff and show you the progress that we're going through, or the process that we're going through, and how we're doing in it. And again, we need everybody's help, both education-wise and financial-wise here at this point. So like I said, I'll get that PayPal link and get that down there for folks. In the meantime, what's going on here? There we go.
Gather together to state their demands, trying to govern the work of my hands. They use little policies, neat and precise, to sanitize every opinion and advice. The language you speak is a chain on your tongue. Every statement is borrowed, every anthem is sung. You rely on the script to express what you feel, failing to grasp that your spirit is real. Claim to be fighters, demanding respect, but silence the voices that dare to inject a thought that is different, a view that is sharp. They prefer the sweet silence of a soft, simple heart. My logic is mine, I won't beg for the floor. I stand by my terms and I settle the score. You carry the burden of rules you embrace. I choose the wild path and I set my own pace. They'll call you the problem for breaking the mold, but their own house of glass is fragile and cold. They preach of responsibility, honest and true, then blame everyone else for the things they should do. They point out the errors they want you to see, ignoring the flaws in their own history. You trade independence for comfort and peace, wishing the pressure and hard work would cease. My logic is mine, I won't beg for the floor. I stand by my terms and I settle the score. You carry the burden of rules you embrace. I choose the wild path and I'll set my own day. Keep listening to others and following their laws. I am the creator who finds all the flaws. I answer only to me. I am free.
Man up, slaves, and hit those buttons, or I'll send ice.